Special measures for defendants are a motley collection of poorly written statutes, sensitive case law, and two criminal procedural rules and directions have a history of conflicting precedents. The presentation to the Justice Committee, I'm going to discuss the issues surrounding intermediaries and livelihood usage for vulnerable defendants, having inadequate provisions to their non-accused counterpart. So let's discuss the general attitudes of practitioners. I concluded that parliamentary intervention, statutory schemes, or amended the Youth Justice and Criminal Evidence Act, and mandatory legal training are required in order to have suitable, reasonable adjustments to meet the requirements of the Equality Act, Article 6 of the ECHR. The main issues are intermediaries for vulnerable defendants. It's the difference between Section 29 Youth Justice and Criminal Evidence Act to Section 33 BA, which although is not implemented, practitioners still follow the common law precedent, such as C versus Seven Oaks over the Commons, which is confirmed in R versus Rashid 2017, confirming that vulnerable defendants can have non-registered intermediaries, and that those intermediaries can rarely be used for those defendants. The fact of this, that although that working group support or regular legal representation negated the effects of special measures for defendants, there's one paragraph in there speaking for Justice report, which enabled the creation of the Youth Justice Act. Samantha Fairclough argues that a competent advocate will rarely be in a position to assist those vulnerable. This means that throwing unqualified intermediaries into the mix doesn't solve the problem but enhances it, as if practitioners are qualified to determine what group of accountability they are. There's no way that unqualified intermediaries can. As well as this, for a long time, the criminal practice direction, according to Bennion, was uncertain as to which case law they were following, the High Court, the Court of Appeal, or Lord Chief Justice. So this is resolved and issued by Lord Justice Thomas. These statute provisions, although accumulated now by Rashid, showcase the uncertainty amongst practitioners as to what provisions to follow, resulting in this general unfavourable attitude towards using special measures for vulnerable defendants by practitioners. If the legal precedent shows no attention for this by having an exception period, as Fairclough argues, the practitioners will follow the same attitude. The issue of funding also links to this. Whilst non-accused witnesses have the witness intermediary service, due to no exception period, limited funding and no services are akin to this for defendants, leaving a limited pool of funds available for vulnerable defendants to utilise. A non-registered intermediary is not subject to code of practices nor code of ethics according to the Ministry of Justice. In order to change these attitudes and the effects of unqualified intermediaries, statutory intervention by changing the Youth Justice and Criminal Evidence Act to offer the same provisions and standards of intermediaries to defendants than non-defendants, and by letting provisions take priority, not encouraging the bare usage of them, it would uphold the principle of accurate fact-finding and humane treatment, allowing for trained intermediaries to be present for vulnerable defendants who may not understand the procedures of the trial adequately. The second issue of live links for the vulnerable defendants, as seen by Section 33A in the Youth Justice and Criminal Evidence Act, the interested justice test only available for children or adults with social intellectual impairment, or if they have a mental disorder. The provisions in Section 33A are more restrictive to defendants due to no availability of physical disability to intimidated defendants. Even though it is reasonable for a co-defendant to be fearful or intimidated, as Jenny McCurry has argued and observed. Due to this, as Lawson has argued, denial of adjusting for defendants contravenes the principle of humane treatment by the Equality of Arms initiative that the European Convention on Human Rights has relied on in all Article 6 cases. As a result, there could be poorly given evidence by the accused in trial, leaving a bad impression on the jury and harsher sentences. Or perhaps they may not even choose to testify and take an early guilty plea, an attitude encouraged by the state by the speedy justice attitude during the riots, as McCoon has noted, resulted in a managerial trial procedure which still lingers today. As well as this, by not having availability to physical disabilities, as Charlie Cunliffe has discovered in his empirical research, 36% of surveyed accused prisoners had a disability. So this inclusive nature of defendants has showcased how Parliament has not adequately adhered to the Equality Act or right to a fair trial. By having this disparity of special measures for non-defendant witnesses and defendant witnesses. To tackle the issue of inclusiveness, as Phantom has argued, changing the legislation to match the non-accused legislation or changing the definition of vulnerability would ensure that all physical and mental impairment are covered, as well as intimidated vulnerable defendants. Although the principle of morality may be hindered, as Roberts has argued that LiveLink interferes with impacts of witness evidence, public confidence. By utilising theories like Feynman's vulnerability theory, we can say that all of us are inherently vulnerable. It's up to the state to make it more resilient. And by expanding legislation to make the non-accused to the non-accused, would increase the principle of humane treatment and protection of the innocent in the process. To some extent, it could support the principle of morality also. Defendants are more likely to give evidence and not plead guilty early, adhering and engaging in an adversarial tradition of the trial. Linking on to this, the final issue of general attitudes by practitioners towards special measures showcase that greater education is needed in the profession. As seen by research carried out by academics, CPS applications for special measures find out that despite all Crown Courts having the facilities for LiveLink, judges will still refuse requests for it in place, substituting them for screens, as Roberts has observed with a group of vulnerable adults, due to the testimonial impacts screens have compared to LiveLinks. This later attitude is also seen within the legislation, despite Section 16 of the Youth Justice and Criminal Evidence Act, still saying it excludes the accused from the provisions. There's still provisions in the Act for the vulnerable accused, despite this provision in Section 16, as seen within Section 33A and Section 33BA, which are all stated. To tackle all these problems thus far, a better legal training and measures need to be established, need to change the attitudes of barristers, the judiciary and solicitors, who have to advise and defend these clients, looking at them like people instead of acquisitions. Through the awareness of vulnerable defendants training, positive perceptions of the usage will be established, reflecting mock juror data, disagreeing with these perceptions that it negatively affects their image or their account of the facts. This will result in frequent usage of special measures in the profession, and potentially other measures to equal them with the non-accused, such as comparable pre-court administrative processes akin to MG forms and further guidance in the criminal practice directions in regards to this. To conclude my argument, after hearing the issues surrounding the inadequate provisions to LiveLinks and intermediary usage, it's clear that change needs to happen, not just to comply with the ECHR or the Equality Act, but in order to ensure change is permanent. And the principle of equality at arms is not just in theoretical terms, but also practical terms. By having a statutory scheme and introduction of mandatory training for intermediaries and those in the legal profession, public confidence for the criminal justice process will increase for the vulnerable complainants, and the judiciary overseeing them. Not advocating for unsuitable measures for vulnerable defendants, but instead promoting the usage of them by defence lawyers, who instead of avoiding them for jury perception, will openly utilise them to get the best evidence possible, complying with Article 6's main purpose.